Greetings, everybody, and thank you for joining us today. Welcome to our presentation on the One Big Beautiful Update for Family Law Professionals. My name is Jane Rowney, and I, along with my colleagues in the Divorce Financial Planning Division of CBM, Jordan Eggert and Abby Frischman, thank you for joining us for this interactive presentation. We've designed this program to address the sections in the One Big Beautiful Bill that are most likely to affect the after-tax income available to divorcing clients and their spouses to create money for their expenses and support. And we also hope to demonstrate to you the impact of wise counseling or of missed opportunities. Okay, so the One Big Beautiful Bill makes many of the individual tax cuts and reforms of the Tax Cuts and Jobs Act permanent. Many of them were set to expire at the end of 2025. In general, for individuals, the Act cuts taxes primarily for working class families. So, with our learning objectives today, we hope that you will leave the seminar with, first of all, a better understanding of the One Big Beautiful Bill as it relates to income tax aspects of financial settlements and how they may impact your clients. We also hope you'll have a better understanding for key considerations in mediation, negotiation, litigation, or collaborative divorce with respect to these tax law changes. We also want to give you some strategies to maximize the income and the tax benefits and avoid some costly tax traps or pitfalls. We also will show you issues that may be encountered and give you help to identify them by examples and some case studies. So our goals today: avoid making costly mistakes, maximize your financial resources, and having no surprise tax consequences.
Okay, so first slide, kind of getting into the meat of the things, is going to be talking a little bit about the state and local, otherwise known as SALT cap increase. So as you can see on the screen, the old rule, which also, just as a side note, does revert back in 2030, had a $10,000 limit. So and again, this is applicable when you're itemizing, but so any state tax and then also any really real estate tax was combining into that $10,000 threshold. But with that, there was no income limit phase out. With the new rule, there's a temporary increase to the SALT cap deduction and also the income eligibility rules to be able to claim that deduction. So that cap increases to $40,000 starting in 2025 for those people filing as single, head of household, or married filing jointly. Married couples filing separately would get $20,000 each. And then from 2026 to 2029, that $40,000 cap grows by 1% per year. But just as a side note, and this is also a new piece, is there is an income-based phase out. So that phase out starts kind of kicking in when your modified adjusted gross income is over $500,000. The deduction is reduced by 30% of the amount over $500,000, and that amount, or really that reduction, goes down to $10,000 as income rises. And also, just one thing to note is that threshold also increases 1% per year through 2029. But once we hit 2030, that cap reverts back to $10,000 for everyone with no income-based adjustments. And also, I mean, this could always change, things become solidified, but as of the way this bill is written now, it does revert back. And this really applies, again, to those clients who itemize on their returns. And also, just important to note, for those who own real estate and are under that phase-out threshold, this would help free up some cash flow. It also will allow more people to itemize on their returns, and is just something to keep in mind when you're working with clients that are going through the process. Okay, so the next piece that has changed a bit is, well, not changed, actually just been made permanent, is the mortgage interest deduction. So back in the Tax Cuts and Jobs Act, they decreased the mortgage interest deduction to have a $750,000 cap. With this change, or with the new big beautiful bill, the home equity loan is now also eligible for that deduction if you're building a home or improving land. And also starting in 2026, mortgage insurance premiums are able to be deducted. Again, this only applies to those people who itemize on their returns, but just one really tax planning tip to keep in the back of your mind is that if you have clients whose mortgage is over $750,000 and they each want to, I don't know, stay on the house, they would each be able to have that $715,000 deduction. So this is a planning opportunity for clients with a high mortgage, if they're able to, if they agree to it, where you could actually really increase that 750,000 limit to really up to 1.5 million, just with this kind of loop. And again, just to note, standard deduction is also remaining high, so not everyone is able to itemize, and we'll touch on this a little bit later on, but for kind of the new act, married filing jointly, standard deductions are $31,500. Head of household is $23,625, and single is $15,750. So again, this is a helpful kind of piece of information if you are able to itemize, but again, not everyone is going to be able to itemize because standard deductions are remaining high. So next slide, and this is a kind of overall new thing, and this is a temporary 25 to 2028 thing, which is if you have a car, or if clients need a new car and kind of need more or less help alleviating some short-term cash flow issues, there is a USA car deduction available. People are able to deduct the interest payments on a loan used to purchase really specifically a new personal use vehicle. So if you do used cars, this doesn't apply. But if you purchase a new vehicle that was manufactured in the United States after December 31st, 2024, you would be, or if you fall within the income parameters, you'd be able to deduct the interest on your tax return. So there's up to a $10,000 annual deduction for US made vehicles. Again, this does phase out for if you're filing single of head of household, the phase out starts at 100,000 and is completely phased out by 149. And if you're married filing jointly, it's 200 to 249 where that phase out applies. So if people with income that fall within that threshold, there would be, you'd be able to deduct the interest that they're paying on their returns, which does again in turn help alleviate cash flow. Okay, so next slide, there is a new additional tax deduction for those people that are 65 plus. And again, this is another rule that reverts back in 2029 unless something else changes. But the old rule here, there's an age-related standard deduction boost of $2,000 for individuals and then $3,200 for couples if you are 65 or over. And the new rule actually gives you an additional $6,000 per individual or $12,000 per married couple if you're filing jointly. This is in addition to the $2,000 or $3,200 based on the old rule. And this is also just as a side note on top of the standard deduction for people that are 65 or over or are blind. This is a below the line deduction, so it doesn't reduce your adjusted gross income. And this applies, again, there is a phase out included. So if you're making between 75 and 175, that phase out would start. if you're filing single or head of household, and then 150 to 250 if you're married filing jointly. And this is a helpful just thing to keep in the back of your mind for clients who are in retirement or nearing retirement, that are living on more of a fixed income. This could be really helpful, and again, would give you an additional just boost of tax savings and allow more money in their pockets. Okay, so there's also an expanded use of 529 accounts, which I think are pretty good and is helpful, I think, in a lot of different cases, at least that I've seen. There are a couple in particular that this is going to be able to be a pretty big game changer. So under the old rules, for kindergarten through 12th grade expenses, there was a $10,000 per year or per child distribution cap per year for private school. And that, again, that was limited to tuition for public, private, or religious schools. And under the new rules, that doubles the distribution cap to up to $20,000 a year per child. And it's also expanded to costs that are outside of tuition. So things like books, curriculum materials, tutoring, online education platforms, subscriptions, educational therapies for students that have disabilities, test fees, and also dual enrollment tuition for college courses taken during high school. And then also, this is a big piece, is it now also expands for workforce trainings, apprenticeships, any sort of licensing or certification programs. And then one last piece to note is that the 529 to 529A ABLE rollovers were made permanent. And this had previously been set to expire at the end of 2025. And I think this piece where it could really be helpful for clients going through a divorce is that 529 funds, if there are excess that the children don't need, or you think scholarships would probably be received for the kids, 529s could be used to help that non-working spouse gain education and training that they would need to re-enter the workforce. And the increased $20,000 distribution cap can also help clients cover that private school tuition. So a bucket of money that had been set aside previously for this could help kind of the immediate need if the kids are in private school. And it also can help parents cover those tutoring test fee expenses that do add up fairly quickly. The next slide, so Trump accounts. This is a new type of, really, it's an individual retirement account. So kids born between 2025 and 2028, there is a $1,000 deposit made by the government. And then with these accounts, there's a $5,000 annual contribution limit. Employers can contribute up to $2,500 a year. And again, this starts adjusting and increasing for inflation in 2027. And this would also grow tax deferred until an account owner makes withdrawals, which can start at age 18. And again, once the kid hits 18, the account similarly follows the rules of an IRA, but withdrawals are from net after-tax contributions before 59.5 would be subject to a 10% penalty plus the income tax, unless it's used for college tuition up to $10,000 for a one-time or a home purchase. And there are kind of a laundry list of other exceptions. So it does give a little bit more flexibility and provides just kind of another type of account that could be utilized in planning for tuition and other expenses.
Okay, so the dependency exemption. We see it written into many agreements as to which parent is going to claim which child as a dependent in which years. So what is this really worth now? Okay, now with under the One Big Beautiful Bill. Well, the deduction has been eliminated permanently for federal tax purposes. However, the eligibility to claim an exemption for a child is important in claiming the child tax credit. So generally, it's the custodial parent who claims the child, unless it's 50-50 custody, and unless the non-custodial parent is provided Form 8332 to release the dependency exemption to the non-custodial parent. Right, I'll explain this a little further in the next slide. So, under the old law, TCJA, it doubled the maximum child tax credit from $1,000 to $2,000 per child for children under 17. And this was set to expire at the end of 2025 and revert back to $1,000 per child. But the new law, and this starts in 2025, that there is a permanent expansion of the credit, which is up to $2,200 per child for children under 17. And starting in 2026, this amount will be indexed for inflation. So that means that the annual credit will continue to go up. Okay, it starts to phase out for single and head of household filers who have $200,000 or more of adjusted gross income. So that's income before deductions. And for if they're married filing joint, it phases out at $400,000 or more of taxable income. So not everybody can actually get this credit. So again, who's eligible? The child has to be under age 17 by the end of the year. They have to be a U.S. citizen or national or resident alien. They have to be claimed as your dependent. They have to possess a valid Social Security number. And only one parent can claim the credit on the child each year. They can alternate, but only one parent per year gets that. And there's an additional eligibility requirement, and that the recipients, the parents, must have a Social Security number. So part of this credit, up to $1,700 per child in 2025, and this is also indexed for inflation each year, so it will go up, is refundable if you don't owe any tax. So that means if you have a spouse with no income and they show zero tax on their tax return, they can still get $1,700 per child by filing a return, claiming the child as a dependent and being eligible for that. So here are some examples for practical uses. You may have parents that have 50-50 custody. So they have two children, both are under 17. Dad makes over $300,000 per year. So if he's filing as head of household, he's now over that threshold, and he's not going to be eligible for the credit. Mom makes $100,000 a year. So dad can still claim the child as a dependent or, take that child, but then waive the dependency exemption to the mom, file Form 8332, so she can claim the child tax credit for both children. And if she has income and she has tax, that could be worth another $2,200, close to $100 a month in child expenses. Dad can still file as the head of household, because generally parents want to be able to file as head of household versus single to get the more favorable tax brackets. And if one of the children is over 17 and one under 17, make sure mom gets the younger child to claim as her dependent so she can get the credit on that child. So another example would be parents have one child in 50-50 custody. They want to alternate claiming the dependency exemption. Dad remarried, and he doesn't need the dependency exemption for filing status because he's going to file married filing joint. And dad and his wife's income is over the threshold, so he wouldn't get the credit anyway. If they alternate year by year, the child tax credit will be lost in the years when dad claims the child. So give it to the mom. Okay, then there's a third example where mom has primary custody and her income is over the threshold for claiming the child tax credit. In this case, she could file Form 8332 and give dad the dependency exemption so he can claim the child tax credit. mom can still file as head of household. It creates more money for the family. It helps with the child's expenses. All right, next slide, please. All right, so I'm going to touch on charitable giving for a minute. For itemizers, there is a floor on adjusted gross income before you can get a benefit. And then there's also a carryover for deductions that have been disallowed. But I want to highlight for non-itemizers, so people who may be taking a standard deduction, if they file single or head of household, they can still get a $1,000 deduction for charitable contributions, or $2,000 if married filing jointly. And you may see this with some parties who have belonged to a temple, or they're partners in a law firm and they contribute through their law firm, and those charitable contributions flow through, that they may otherwise may not have a lot of extra money to make charitable contributions in the year of the divorce, but they may have some from which they can benefit from this rule. There's also a scholarship credit. It's 100% of up to $1,700 for gifts to scholarship granting organizations, and that's an actual credit, not a deduction. So here's some other changes I just want to touch on. We're not as likely to see these in our divorce cases, but they may come up. Abby already mentioned that the standard deduction has increased, so that means fewer people will itemize. Maybe there's less need for deciding who gets what deductions in the year of divorce. And then there's a limitation on itemized deductions for high earners. So if you're in the top tax bracket, you're not going to be able to take all the itemized deductions you might have. It's going to be limited to the 35% tax rate. There's a qualified business income deduction for business owners. That has been made permanent, and there are phase outs for income. And then also there are special rules when it's service income. Another item you probably have heard of is no tax on tips and overtime for non-itemizers. And this is in effect for 25 through 28. So again, there are thresholds for single or head of household, married filing joint. That does phase out with higher incomes. There's also some student loan debt relief exclusion. In general, forgiven balances will be taxable income after 2025. However, if they die or they're disabled, that is not taxable income if the debt is forgiven. And then an employer can pay up to $5,250 of loan payments and have that be tax-free to the person holding the loan. One last item, the gift and estate tax exemption, that threshold is up to $15 million in 2026 with inflation increases.
Great. So I just wanted to chime in. We have a pretty interesting case study for an engagement that we're working on that's somewhat fresh and interestingly enough has all different impacts on what I call OBBB or OBBB, the TCJA Act, and kind of timing of how this new regulatory tax provisions that went into place this year impact negotiations and impact how we look at support. I'll give you some of the background on these imaginary clients. Some of the numbers and names have changed, obviously, and then kind of work you through the timeline of what we dealt with. And I really want to hone in on a timeline because we'll be facing this again likely come 2029 when much of the tax provisions either sunset or some permanence comes into play for some of the regulations, or there may be an extension. It's kind of the Wild West when you start talking about tax regs and administration changes. So in this specific case, we had two clients, very long-term marriage, 25 years. They're a bit older, 71 years for Elana, Bernie's 65, still working, high income earner. The interesting part was their income was just above the $500,000 threshold. So now we have all this phase out of SALT to think about. They both live in DC, have a house valued at over $2 million with a $25,000 property tax bill. And then they have some general cash. And so in this case, we had a lot of issues that popped up. One was that there was a pretty lofty budget for Elana. And then Bernie, on the other hand, although he had a high income, was on a ramen and rice and chicken budget, trying to afford housing for both of them, food for both of them, support both of their budgets. Elana thought there was more than there actually was. Bernie doesn't want to work any longer. And there's a discrepancy on what equitable support is. This was a pretty, we'll say, neutral-ish or neutral light sort of engagement, where the clients and the spouses were talking back and forth and trying to come up with some sort of semblance of a reasonable approach for support. So not only was there a disagreement amongst the spouses about having more support versus less support, there was a disagreement between the attorneys about what constitutes support and what constitutes income and available assets to utilize. And then most importantly, there was a discrepancy amongst the CPAs and the financials. And once we go to the next slide in a moment, you'll see kind of the progression of that, and we'll talk a little bit more about that. So a lot of the support came down to figuring out not just what happens the next 4 or 5 years for Bernie, since he's the income earning spouse, and how much support would be based off of, but what happens for the rest of the period. This is, pretty much a permanent support case. What happens for the rest of their actuarial life expectancies? So it kind of got to the point where we started talking about future projections and future income and future strings of asset drawdowns. And there was a lot that was going back and forth and ping-ponging between who was right, who was wrong, who was conservative, who was speculating. So I won't go through all the dates, but it was almost the perfect storm here, which, again, this can very much repeat itself once we hit 2027, 28. But we started this case back in 2023. And then in 2024, we started ping-ponging, frameworks, models back and forth, back when all we knew was that there was a $10,000 SALT cap. So our projections, we ran 15, 20-year projections, were all based on a $10,000 permanent sort of SALT cap. As we got into 2024, we found out that, okay, well, maybe that cap may not exist, so it might revert back to complete allowance of state and local income taxes. So we redid our projections again that way, and all of a sudden the resources skyrocketed, right? So for the next 20 years, you have, I think the state income tax is something around $40,000 or $50,000. You had an extra, there's approximately $12,000 a year available for resource purposes that could be earmarked towards alimony. Fast forward into 2025. At the beginning, we started hearing rumblings that might not be the case. We might have the cap extended to $10,000 again. Fast forward again to just a couple months ago, and we're still going through negotiations. And everything has kind of turned upside down, because not only did the cap get removed, it just basically got pushed up a little bit. It went from $10,000 to a $40,000 cap. Great, we ran the projections again, came up with what the resources would be, and then a month later, when the bill came out, it turns out it was only for 4 or 5 years that $40,000 cap for state and local tax triggered, and then reverts permanently until there's additional tax regulation to a $10,000 cap. So if I just confused you, I probably did a good job then, because it's very confusing to us too, right? There's a lot of projection that we have to do when you're looking at a long-term time frame. My approach and the approach that the entire team took was of conservatism. We can only present and really calculate based on today's rules that we know are in place. It's kind of like I have a really good analogy for anyone that likes Back to the Future. If you remember the chalkboard or the whiteboard in Doc's lab, you're kind of at the juxtaposition of where you can choose going down timeline A based on, the OBB rules now, or you can choose going down on timeline B, which is OBB rules and then a change in 2029. It kind of delineates itself. So what we ended up at the finality doing, and the trial is still upcoming, so it'll be interesting to see how the judge considers this. But what we ended up doing is running two scenarios. One was permanent installation of reverting back to the SALT cap after 2029. And then one was seeing if there was an extension onto onward from 2029 forward. Again, there's a lot that changes. So our approach was we'll see where both of them land and kind of establish some goalpost, if you will, to have a robust conversation and present to the courts to say, okay, well, if it goes this way, we know it's X dollars available for resources. Otherwise, Y available for resources. And really, we have to start thinking of that when we're talking about taxes. At the end of the day, it's really difficult to project, beyond a few years, given all the change that's happening. So one of the things that our team does and that many financial professionals will do is we'll run early tax projections and early retirement projections to see what the impacts are to both spouses, to see how much in resources are available, and then stress test in a worst case scenario to see, okay, well, if things change and they change for, lack of a better term, the worse, here's kind of where things might shake out. So typically we would compare different scenarios of who keeps what assets, who takes which deductions, and we try to make sure we're analyzing all the different routes that they could go. One of the things that I think is important too, when you're involved in issues regarding support or regarding where assets play a big piece and income plays a big piece in settlement options, is really honing in on negotiating based on predictable tax rules. We know that the permanence of some of the TCJA under the OBBB gives more stability, so we have lower brackets, predictable standard deductions, and so we can kind of structure support and division in a way that reduces risk of one spouse's income fluctuates. But we'll talk about a little bit more in a minute when Abby and I have more of an open forum on some settlement option considerations, that while structure is important, we also want to make sure that we have some caveats in any sort of separation agreements or any sort of negotiations, that if there is a change, if there is a tax windfall, if there is, some unforeseen, big triggering event for phase outs, phase ins, that there is some consideration for what happens then. So in this case, if all of a sudden the cap is unrestricted for state and local tax, that completely changes after 2029. That completely changes the approach and a view of both the clients, the attorneys, the professionals, and also the courts of what's available and what might be considered for resources. So lots to take in there, but the big takeaway is that there's a lot of planning opportunities around the state and local tax matters. And there's a lot of kind of grayness. We have an idea of what happens over the next couple of years, but beyond that, we just have a general semblance of what's happening. So what we can do now is just mitigate sort of that exposure of the unknown and just make sure our clients are well versed enough to understand, here's what timeline A looks like, and here's what timeline B might look like. Okay, and so just a precursor before we jump into things, it's very important that everyone understands, and this is from my own experience and other financial professionals' experience, that many of the softwares don't have OBB or OBBB integration yet, meaning that if someone is just relying on putting some numbers into a tax projection software or a financial projection package software, there is a over, I would say 75% chance that the projection software and that the calculations are incorrect because they haven't been integrated yet for all the changes that have happened for OBBB. So it's really important that when you're looking at after-tax resources and you're looking at net income cash flows of both parties, that you understand what's kind of feeding in the calculations and maybe question them as well to ensure that they are encompassing these tax changes. Because we're still, I know for us personally, we're still waiting for the integration of OBBB into our packages. So we had to manually calculate everything, and it's still months before they'll finish integrating that. So just something to think about as you're looking at all the different information coming back and forth from all the parties involved.
If you were to superimpose the pre and post, you talked about these, the Excels that you put together and the savings and the different cash flow. What is the relative difference for this particular person of cash flow? Because she
Sure.
didn't have very much income to begin with. The alimony in this case is going to be tax-free. I guess, so was that a game changer or not?
Great.
I guess
Yeah,
is what
great
I'm
question. Great question. So without going too far down the rabbit hole, we had a lot of opportunity to plan how things would work and free up cash flow for support purposes. So one of the things, or let me dial back. Basically, what ended up happening is there was another, I think it worked out that there was another $1,000 a month that was available for support. And so that bumped up, I think it came out to like $800 additional on the spouse's side that was available to pay her from that additional resource free up for support. More importantly, what we were able to do was consider how the assets were being divided. So we were able to push some more of the retirement assets to her that were taxable at a lower tax rate. And also on top of that, let her keep the house, or let her pay the property tax in the house that she was living in. So she'd also get the additional tax deduction on there. So beyond just creating additional support, which was a little under $1,000 a month, we also created more tax-free income and increased her resources as well. So it's not, if you're looking for the smoking gun of having, multiple tens of thousands of dollars freed up by SALT considerations, probably not going to happen unless it's completely unrestricted again. When you start talking about a $40,000 cap and phase outs and considerations for that, you're probably looking at about maybe $1,000 a month of freed up resources, presuming you hit the maximum $40,000 cap.
One consideration on that is like if you're looking at the income phase outs and you're making enough to be maxing out at the 40,000, I mean, that's not always going to be kind of attainable at that kind of cash flow level.
So there's I would say maybe 50 or 60 ways to skin the cat there. Fortunately for us, given I guess how little the types of assets were, there was a lot of flexibility with this specific retirement account of divvying that up against the house. So you're able to kind of figure out how to maximize tax efficiencies while also maximizing the benefit from the SALT cap. And that's the importance and the value you get from running retirement projections or financial projections. I don't want to say it's a best guess, but you're definitely analyzing things to see how you can maximize efficiencies and maximize additional resources, which is important, especially in cases where there might not be enough resources to support two budgets on their own.
So just some kind of tips and best practices for drafting agreements with this new bill in mind. It's just kind of following what Jordan said, is just to be very clear in the agreements that if future tax laws change, the projections we're running could change. So again, projections that we're using to kind of help inform settlements, I mean, there could be something that changes pretty significantly, but we don't know what that looks like because we have no idea what any sort of future tax law kind of changes will be. And also just making sure you're aware of the time periods for some of the changes, for instance, like the SALT cap, the $40,000, that reverts back to 10,000 in 2030. So that's only the next few years. So if you're structuring things that allow, or just you have a creative settlement where you're kind of trying to maximize the itemized deductions, you could just in the back of your mind being like, okay, this may not apply after 2030. That could be maybe some sort of timeline where payments or direct payments change, so one person would be able to maximize, but maybe both people wouldn't be able to maximize what their deductions are once it reverts back.
Right. And so exactly like Abby was saying, because the SALT cap relief is effectively temporary until it's not, even though they say it's a permanent change back to the $10,000 cap, we all know what permanence looks like these days, that it may make sense to build in triggers or review dates in a divorce agreements. So for example, a clause that when SALT cap reverts, support payments may be reviewed or renegotiated within, a certain boundary. So maybe if it changes more than $5,000, whatever the amount is, you could have some terms and some additional rules and trigger points for that. So the consideration, and Abby and I had talked about this a while ago, are thinking about, what other tax paragraphs to include in there. I have a slide on there that we'll talk about in a bit, but you basically want to make sure you have enough coverage where one spouse doesn't have a windfall because the tax code changes and one doesn't have a complete detriment to their future financial prowess or financial goals. So that's something that we really wanted to be clear on, is that we spell out as well in the agreement, maybe the intent of who gets SALT deductions, maybe clarifying who claims a child tax credit in which years, which we generally do, but even now it's even more important. And then clarify also who, what the intent is of paying property taxes or what the intent is of taking other deductions. And again, under the premise that it's current tax rules that it may trigger a revision or a modification if there is XYZ change.
Yeah.
One of the things too that I want to chat about is whether or not structuring agreements to take advantage of tax reform and tax regulations is okay or not okay. I had an article several years ago that's a few slides up that was really interesting and pretty impactful, that our agreements are really based on what our clients' needs are and wants are. So the ability to pay, the ability to have resources, the ability to have an equitable sort of settlement. That's all great in the civil side of things. There is a complete disconnect, though, from the IRS, or not disconnect, but a complete independence from the IRS. There's a pretty big separation. The IRS is a separate entity that views things differently, or can view things differently than in civil process. So in a civil process, we get a little bit more creative. The states have guidance, counties have guidance, and then ultimately there's different legislation, regulations, et cetera, that we work by. The IRS, however, can see things differently. And I've not run into this yet, but it got postured out there that there is a revenue ruling 76253 that the IRS can completely disregard a divorce if they think it's obtained solely for the purpose of saving money on taxes. To what level does that trigger? I don't know. Again, I've never seen it happen. But one of the things that we'd want to consider is additional verbiage or language inside the separation agreement that says, there's a irrefutable or unreconcilable dispute amongst the spouses, and the equitable distribution and how assets are split are not done pursuant to tax savings purposes. Something to that extent. And I found that that's just an extra layer of coverage as well, in case the IRS comes back and says, oh, well, how is it possible you had $1 million of income and only paid $1,000 of taxes? And then the answer is, well, we arbitraged everything in our settlement agreement, or arbitraged everything in our negotiations, just having an extra line of defense. And so just food for thought for everyone. to think about that you may want a little paragraph inside the separation agreement to that extent.
Yeah, so just some tips, tricks, things to keep in mind for drafting agreements, and also just kind of best practice too is being kind of mindful if you're trying to maximize, okay, who's paying what in the agreement. I mean, typically, at least on mortgage interest deductions, real estate tax, typically follows who pays. So just keeping in mind the structure of how you're creating the agreement. So if you're intending to, again, maximize kind of dollars and say tax savings, instead of, let's just say, having husband pay the mortgage for the house that wife's staying in for however many years, maybe that could be included in support payments, and then she would then go ahead and pay that, so she would be able to get the benefit if he was kind of over the threshold of being able to actually benefit from those deductions. We also need to be careful on what terms we're using. It's better to be kind of very clear and very well defined, and also just sharing, and just again, as Jordan had said, putting kind of an explanation of the intention in the agreement as well.
Right.
Yeah.
And to that extent, I think what we'll find is citing IRS codes or citing regulations and putting, actual meaningful references in there will pay dividends for us when we look at the agreement down the line and say, oh, why did we come up with that? Or why did we think that that was the right support? And just kind of a little bit of showing your work, if you will, inside the agreement will pay dividends.
Yes. And then it's just, one thing to keep in mind also when drafting the agreements is, again, the clearer you can be, the better. So if there is some sort of true up or reconciliation that has to be done, it's very clear and very specific without much open interpretation to have that all right there. So that kind of protects you from any kind of after the fact back and forth arguments between parties because they thought two different things, or their interpretation meant two different things of what they actually ended up agreeing to.
I've seen this in prenups. The one that comes to my mind is spousal support, where I've seen prenups written that included an amount of support, but never addressed whether or not it would be taxable to the recipient or deductible by the payor. And now parties getting divorced, it's gray as to how this will be treated. So again, going back to intent and having some language in a prenup, in a postnup, or in a separation agreement as to how do you address these tax law changes, because they will change. None of the tax laws, many of the tax laws will likely change over time.
That's correct.
Yeah, that's correct. And that's a big kind of question that I've heard when prenups are kind of in the picture is support and taxability of support if it was from a pre-TCJA agreement.
Right. That'll be interesting too. While we have permanence and tax code can be, taken as permanent, there can always be an override and Congress could come in and change the rules of the game. So it's really important that we all keep up as professionals, not just on the finance side, but on a legal side, on the mental health, on the ancillary professional side, what's going on in the tax world, because it does impact every phase of the divorce process.
Yeah.
Well, thank you everyone for joining us today. It was great to see your faces, hear your voices. We appreciate your participation. There is a slide at the end with some helpful resources, but also feel free to reach out to any of us if you have follow-up questions.